Lawmaking. Judicial precedent. Hierarchy of the courts. Within the doctrine of judicial precedent, there exists a hierarchy of the courts. The basic rule is that a court must follow the precedents from a higher court, but they are not bound to follow decisions from courts lower in the hierarchy. A basic outline of the hierarchy is the Supreme Court, formerly House of Lords, the Court of Appeal, the courts of the High Court, all other courts, county, crown, magistrates, tribunals. Where the precedent was set by a court of the same level, the court is generally bound by the previous decision, but this is subject to exceptions. Different considerations apply, depending on the level of court, as to whether the court may depart from a previous decision of a court of the same level. The House of Lords was replaced by the Supreme Court on the 1st of October 2009. The Supreme Court has the same jurisdiction as the House of Lords, and the Law Lords took office as Justices of the Supreme Court. London Street Tramways v. London County Council, 1898, established that the House of Lords were absolutely bound by their own previous decisions. However, in 1966 the Lord Chancellor, Lord Gardiner, issued a practice statement allowing the House of Lords to depart from a previous decision where it appears right to do so. That is, where it would lead to injustice in a particular case or hamper the proper development of the law. Whilst the House of Lords had this power, they were reluctant to use it. In Nuller v. DPP, 1973, they refused to overrule the controversial case of Shaw v. DPP, 1962, despite the fact that the majority thought Shaw was wrongly decided. Lord Reed stated, "In the general interest of certainty in the law, we must be sure that there is some very good reason before we so act." In considering whether to use the 1966 practice statement, the Supreme Court needs to be mindful of the retrospective effect of their decisions. In Cunningham, 1982, the House of Lords refused to overrule the previous decision of R. v. Vickers, 1957, relating to the mens rea of murder. This was because of the retrospective effect it would have on those convicted of murder under the previous ruling and may have been subject to the death penalty. Despite the reluctance to use the 1966 practice statement, there have been a number of notable cases where the House of Lords have used their power. In British Railways Board v. Harrington, 1972, the House of Lords used the practice statement to overrule Addy v. Dumbreck, 1929, on an occupier's duty owed to trespassers. In Pepper v. Hart, 1993, the Lords overruled Davis v. Johnson, 1978, regarding the use of Hansard as an aid to statutory interpretation. In RVG&R, 2003, the House of Lords overruled MPC v. Caldwell, 1982, in relation to the test of recklessness applicable for criminal damage. The House of Lords in R.V. Howe and Bannister, 1987, overruled DPP for Northern Ireland v. Lynch, 1975, in relation to the availability of the defence of duress to an accessory to murder. The Court of Appeal is bound by judgments from the House of Lords and Supreme Court. It is generally bound by its own previous decisions, however this is subject to the exceptions set out in Young v. Bristol Aeroplane. The three exceptions are: 1. Where the previous decision was made per incuriam. 2. Where a subsequent decision of the House of Lords was inconsistent. Or 3. Where there are two conflicting previous decisions. Per incuriam means in error. If the previous decision of the Court of Appeal can be shown to be demonstrably wrong, the Court of Appeal may depart from it. It must relate to an error in the law, for example a statute or precedent had been overlooked. They cannot depart simply because they believe the outcome was wrong in principle or unfair. The Court of Appeal is absolutely bound by the decisions of the House of Lords and now the Supreme Court. If a previous Court of Appeal decision has been overruled by the House of Lords or the Supreme Court, the Court of Appeal must depart from the previous Court of Appeal decision and follow the binding precedent from the House of Lords or Supreme Court. If the Court of Appeal always follows its own decisions, this should not arise. However, on occasions it may happen, if cases are decided simultaneously or a prior precedent was overlooked. Where this does occur, the Court of Appeal may select which of the two precedents to follow and will have to depart from the other. In R. v. Gould, 1968, Lord Justice Diplock stated greater flexibility is afforded to the Criminal Division of the Court of Appeal and they may depart notwithstanding it does not come within any of the exceptions set out in Young v. Bristol Aeroplane. Lord Denning was critical of the constraint operating on the Court of Appeal and wished to have the same power to depart as enjoyed by the House of Lords. He attempted to evade the rule in Davis v. Johnson. However, on appeal to the House of Lords, the Lords were critical of Denning's approach and affirmed that the 1966 practice statement was for the exclusive use of the House of Lords. Lord Denning continued his argument in his academic work, What Next in Law? He argued not all cases get to the House of Lords. Litigants may not be able to afford to appeal or may be bought off by the more powerful. He suspected this was going on in the case of Oliver v. Ashman, in which an error in favor of insurance companies took 20 years to get to the Lords to correct the error. In Rickards v. Rickards, 1989, it was accepted that in exceptional circumstances and where it is clear that an appeal to the final appeal court is not possible, the Court of Appeal may depart from its previous decision. Divisional Courts of the High Court. The divisional courts are bound by the Supreme Court, House of Lords, and Court of Appeal. They are also bound by their own previous decisions subject to the same exceptions set out in Young v. Bristol Aeroplane. The Crown Court, County Court, Magistrates' Court and tribunals are bound by the decisions from the House of Lords, the Supreme Court, the Court of Appeal and High Court. These courts primarily deal with trials rather than appeals and have no power to create precedents. In summary, within the doctrine of judicial precedent, the courts are organized into a hierarchy with the Supreme Court at the top. Each court must follow the decisions of the courts above them in the hierarchy, but do not have to follow the decisions set at a court below them. When faced with a precedent set in the same level of court, the Supreme Court has the greatest flexibility with the power to depart where it appears right to do so under the 1966 practice statement. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.